The first thing she did was park her car crosswise in my driveway like she owned the sunset stand and sunglasses with her hands on her hips, and then she called the cops on me for trespassing right as I was trying to move into my own house, which is a sentence I had never expected to say out loud. But there we were. I remember feeling that weird, raw mix of disbelief and almost laughing anger, like, are you serious? And the neighborhood folding itself into a small, perfect audience. I pulled up to Riverside Oaks a little after 7, the kind of morning that smells like fresh paint and possibility boxes stacked in the back of the truck, coffee still warm in the cup holder. 3 identical mailboxes, 3 identical lawns, and a woman named Karen Mitchell standing in the road, her little staging crew lined up behind her, like they were about to enforce some civic ritual. "You're not moving in," she said flat and loud, and I blinked because I'd never been told I couldn't live where I had a deed and a stamp and a county seal in my folder, all of which, spoiler, were in my glove compartment. She told me the access road was HOA property and therefore off limits until I paid dues and submitted architectural approvals, as if paperwork could rewrite a deed that the county had already recorded, and then, like someone performing a practice bit, she hit speed dial and announced to dispatch that a trespasser was attempting to occupy HOA land. They do things in little ceremonial steps when they're trying to feel official. I stood there hands empty and thought, not today. Not on my move-in day. When the cruiser rolled up, I could tell the older officer from the younger by the way they walked steady versus sharp. Karen rushed them with the zeal of someone who'd rehearsed this, and I pulled the brown folder from the glove box and set it on the hood, the county seal catching the morning. Their eyes slid over the paper, then back at her. "If it's recorded," the younger one said, "we don't enforce HOA bylaws." She tried to turn scripture into law. She had the bylaws printed, fines on HOA letterhead, the whole pageant, but recorded deeds have a louder voice than bullet point regulations. The cruiser idled with the kind of patience you only see when people who read forms all day are waiting for one to settle. Karen retreated to her car and parked along the curb, furious and theatrically wounded. I eased the truck into my driveway and thought briefly that a move-in should feel simpler than this. I was wrong. Over the next 48 hours, things escalated the way small injustices do when someone decides entitlement is a right. Violation notices appeared like white flags taped to my door. Emails arrived with subject lines designed to make your heart jump. Final warning, 48 hours. An envelope slipped under my door with the quiet aggression of a threat. Then the real blow, a lien. Karen had filed a lien against my property claiming unpaid HOA dues tied to that access road. Not a threat. Filed. The county index had the recording number. When I called Marcus, my friend and lawyer, practical as a filing cabinet, his voice went low and focused. "We bring out the original title records," he said, and suddenly those papers in my folder felt like a plan. That night, under porch light that made everything look honest and small, Marcus and I walked into the HOA meeting at Karen's house. She opened the door before we could knock, like she'd been watching the blinds for a drama to begin. Folding chairs, polos embroidered with Riverside Oaks, a coffee tray, untouched, all the stage props of community governance. I set the folder on the coffee table and let the soft thud do the talking. Marcus clicked his laptop and put the county records up on the TV. The screen filled with plats and deeds older than the HOA, older than Karen's little reign. The access road was listed where it belonged, not as HOA property, but as part of a parcel I had legally purchased at auction when the developer folded. The room 30 people used to believing a story went quiet as a house before judgment. You learn something important in a moment like that. Authority without ownership is theater, and theater is fragile when someone brings receipts. Faces changed, embarrassment, surprise, a flicker of betrayal, and Karen's composure cracked in a way that felt dangerous and somehow inevitable. She vowed to sue. She threatened court. She called it a community betrayal. I didn't want a spectacle. I wanted to live. But when someone turns the street into a stage and calls the cops on a man with deeds, you either let the script be written by loudness or you let the law do its steady work. I chose the latter. The mediation was where the twist landed, and if you like courtroom drama, this is where you sit up. Judge Hoffman, retired Judge Energy but still sharp, read the packet, listened to Marcus, and said what county records had already whispered: control is not ownership. The HOA withdrew its lien in the lawsuit. They could, if we agreed, negotiate a transfer of the road under conditions, but the county's recorded title was clear, and now finally so were the neighbors. The immediate victory felt clean, but it didn't end the story. People who lean on false authority don't usually fold peacefully. They escalate in quieter, meaner ways. Two facts made everything worse and then better in the strangest order. First, when we pulled payment history, the woman who'd been shouting about stolen streets wasn't a homeowner at all. She was a tenant in one of my lots, month to month and 3 months behind on rent. Second, after the court ruling, a string of anonymous code complaints hit city enforcement: overgrown grass, illegal signage, suspicious activity, 12 reports, same phrasing, same pattern. They landed in my mailbox like a campaign of paper. Marcus called it strategy. I called it harassment. He called it evidence. He showed the IP logs. He showed security footage of Karen at the public library terminal submitting the complaints. The pattern was a map of escalation. When you can't own the road, you try to claim chaos. We took that to court too. The judge this time, Judge Morrison, didn't rehearse the ownership question that had been settled. He focused on conduct. The evidence was patient and awful. IP timestamps, camera stills, complaint logs, and a trail that tied each attempt to interfere back to Karen. The court issued a restraining order: stay 500 feet away from the access road properties, and later awarded damages for back rent inspection costs, vandalism, and harassment. It was dry and official, not dramatic, just ink and numbers, and the courthouse clerks doing their jobs, but it enforced something quiet, and massive actions have consequences. There's a brutal clarity to being right on paper. It's not triumphant fireworks, it's the slow, steady collapse of a narrative built on belief instead of fact. Karen lost her position, was evicted for non-payment, tried to rally the neighborhood on social posts, and ended up with wage garnishment for the judgment she didn't satisfy. She kept calling it oppression. Most people stopped listening after the restraining order and the judgment. The road got signs that mattered. The HOA started publishing transparent reports pinned to the clubhouse bulletin board, boring stuff like invoices and votes and maintenance logs, and the neighborhood for the first time in months inhaled. Kids rode bikes again. Moving vans pulled into driveways without orchestration. It all felt ordinary and fragile, and exactly what I'd wanted from the start. If there's a lesson stitched into this whole mess, it's not some neat moral about victory. It's that power is often a fog, loud and persuasive, and it only looks real until something solid is placed in front of it. Paper-recorded deeds, timestamps, receipts, the things you file and index and double-check, they don't look like justice when you first need them. They look like boring admin. But the boring stuff is what makes democracy and property and fairness work. When someone treats authority like a script, the only thing that counters it is the kind of steady, patient truth that won't roar, but will outlast the shout. I felt little victories along the way. The cruiser idling while the officer read my deed. The hush in the room when the plat map showed the road where the deed said it was. The tow chain clanking on Karen's car when she parked under the new sign. But the real relief came later, a year after the first confrontation, with a morning so ordinary I almost missed it. A young family backing a truck into a driveway, a boy clutching a toy truck, someone asking, "This the right place?" and a neighbor laughing. "Yeah, right here." No drama, no cameras, no call to dispatch. Just a street that worked like a street. That's the kind of justice that settles in slow and keeps staying. So what do you do if false authority presses down on you? You gather the records. You let facts be louder than beliefs. You don't respond with theatrics. You respond with receipts and steady procedure. It isn't romantic and it isn't immediate, but it ends up being more durable than any shouted claim. And if you've ever had someone insist that they run something simply because they've been doing it loudly for a while, tell me. Tell the story. Share the documents. Because healing starts when the record is clear, and community starts when people stop confusing confidence for right. What would you have done in my place? Stand your ground the first day? Or let the papers do the talking and risk the slow burn? Tell me your version. Or tell me a time you faced a person who claimed power they didn't have. I want to hear how it turned out for you.